Today we talk about what every inventor needs to know about IP. First, IP is about leverage, not about paperwork. IP isn't just a filing exercise, it's a business weapon. It protects your market share, blocks competitors, increases valuation, and strengthens your negotiation position when you license your invention. So inventors who treat IP as an afterthought lose leverage they never get back. So think of IP as an arm that leverages your invention. Second, patents protect how something works. So a patent gives you the right to exclude others from making, using, or selling this particular device or invention of yours. It protects mechanisms, systems, algorithm or software, and technical improvements, not ideas in the abstract. So in the old days, Amazon filed for a patent that says it's a one-click ordering system. So that's an abstract idea. And 20 years ago, they were able to get that. And Apple and other companies had to pay royalties for that idea. And of course, there was an industry uproar. The patent office now blocks abstract ideas from being patented in the US. And that's the same issue in Europe as well. The key rule is you need to deal with how it works. And if you can't explain how it works in detail, then you can't patent it. Next is public disclosure. The minute that you put your invention into paper and you put it on the internet, for example, or you sell it, that is a public disclosure and that can kill your rights. In the US, we have a 1 year where people can recover from that mistake. But in Europe and in China and overseas, that can be fatal. So before you disclose your idea or you offer it for sale, make sure you patent it. And ultimately, if you want to do that at a low cost, you might want to file a provisional application. But if you're ready to go with the idea, then file a non-provisional because it gets you examined much earlier. Number 4 is not everything is patentable. To be patentable, the invention has to be novel, non-obvious, useful, and described fully so that somebody's skill can implement it. Software and AI are definitely patentable subject matter, but only when you frame as a technical improvement, not as a business method. Number 5, a patent is only as strong as its claims. So when you review the application, the description details how it works, but the claim is really the legally important section on the coverage of the invention. In general, a longer claim means you have a narrower invention, but sometimes a narrower claim might be very good. Let's say if you had a very specific claim to GPT, even if it's narrow, it's still very useful because it covers a wide breadth of commercial activities on AI transformer technology, as an example, right? So as inventors, you should understand independent versus dependent claim strategy to give you the maximum protection and how claims map to real-world infringement. And of course, there's a mirror to that, how claims can avoid prior art. What is the one feature you have that the prior art doesn't have? So the proper claim scope is always a balance between the infringement and the prior art. The next point, number 6, is that you need a global patent strategy early. Why is this important? Once you file it, you're going to have to figure out where you're selling it to. And so wherever you sell it to outside the US, you have a 1 year grace period to a patent in that country. So after you file in the US, within 1 year, you need to decide what countries you're going to. And so that means you need to sit back and think through about your customers. If you're a consumer product, then definitely the traditional Europe, China, Japan, the big industrial countries, that block would make sense. Now, for example, if you happen to be serving a very narrow niche market, let's say in farming, you would want to focus only in countries where there's a lot of farm operations are done. You don't care about consumer countries because they're not farmers. So think through your global patent protection strategy because that's going to ultimately affect your bottom line. These patents are expensive, right? 7, the IP ownership must be clean. So you need to make sure that your employment agreement with your employees and your contractor agreement clearly spell out that you own all the rights. And then you need to record those assignments with the patent office. In cases where you have joint development, let's say very common with universities, you need to make sure the rights are parsed out so that it's very clear at the beginning who owns what. A messy chain of title can kill the deal's funding or enforcement. So make sure that you own the IP. Number 8, trade secrets are often more valuable than patents. Not everything should be patented. Some inventions are better protected as a proprietary algorithm, a manufacturing process, data sets, custom models, or internal tool. If, let's say, your company specializes in training data, the end users will never need to see how it's done. So therefore, the training is typically kept as a trade secret. So that's an example of areas that you should consider trade secret. Now, if somehow they can look at the product and reverse engineer the trade secret, then you want to patent them as soon as possible. So an example is the Coke formula. Millions of people drink that every day, but no one can figure out the Coke formula from just drinking it. So the trade secrets can last in perpetuity. And so that's a huge advantage over patents where it lasts only 20 years and you've got to tell everybody how it's done. So consider trade secret as part of your arsenal. Number 9, IP requires maintenance. Patents requires periodic maintenance fees, and on top of that, you have to monitor for people who infringe, and then you have to pay to enforce. You have to constantly be looking for infringers. And then, of course, because of these costs can mount up, you need to prune your portfolio, and you need to have a strategy on how you decide what to keep. And then for those that you don't want to keep, you need to figure out whether or not you're going to sell it or you're going to just abandon it. The patent process is ongoing and it requires maintenance. And a patent that you don't enforce is just a frame certificate. So think of it that way. Number 10, IP must align with the business strategy. That's very clear from this. The best portfolio protects the core revenue, blocks the competitors, support licensing activities, and strengthen your valuation. And it creates a negotiation leverage when you need to go into partnership discussions or when you need to sell the patent or license the patent. So inventors should always ask, how does this IP help my business? Those are the top 10 things that inventors should know. If you have more questions, feel free to visit patentpc.com and I'll be happy to discuss with you.